Welcome and thank you for joining us on this very sunny evening for the latest in the Cambridge University Arbitration Society's lecture series. We're very lucky this evening to have Ian Gaunt and Clive Aston with us. Both are very experienced maritime law practitioners, arbitrators and former presidents of the London Maritime Arbitrators Association. Each of them will speak for around 25 minutes. First of all, Ian will give us an overview of maritime arbitration in London, and then Clive will take us through a case study on the Ever Given, which, as I'm sure everyone remembers, blocked the Suez Canal back in March. And there'll then be an opportunity for some questions. So if you do have any, please type them into the Q&A box at the bottom of your screen as we go along. And just so everyone's aware, the session is being recorded. So without further ado, we will just load up some slides and then I will hand over to Ian for whenever he's ready to begin.
Perhaps I could go back one slide, in fact. Right. Well, good evening, ladies and gentlemen, and or good day to those of you who are in different parts of the world. It's a pleasure to be able to speak to the Cambridge University Arbitration Society, one which we hope we will be able to work with closely in future. Some of you might know that Ibrahim Al-Turki, your president, and I were involved in coaching the Cambridge team for the Vismoot this year, and hopefully we'll do the same next year. And we hope that Cambridge will be able to field a very effective team, as indeed they did this year in the Vismoot, and indeed possibly that some of you might join us in that. As Alex has said, I am a maritime arbitrator by profession. I'm a former president of the London Maritime Arbitrators Association, and one of my tasks today will be to tell you something about the work of the London Maritime Arbitrators Association, and in particular the significance of maritime arbitration and indeed ad hoc arbitration in the arbitration constellation in London and the wider world. Obviously, we're focused principally on maritime cases, and there on the slide you see a ship. It's not the Ever Given, but it's a fairly large container ship of the type that Clive will be talking about later in the presentation. It almost looks, although I'm not sure about this, that it might be in the Suez Canal, but it looks as though it's going the right way. Could I have the first slide then, please? So what is the scope of this maritime activity which we're conducting in London? I think it's important to start by understanding that most contracts for maritime transportation are subject to arbitration. And the scale of this is enormous. Something like 95% of the world's cargo transportation, international transportation, is by sea. It's only very high value items which tend to be transported by air. So most bulk cargoes and many cargoes whose arrival is not so critical in terms of time are transported by sea, and that includes cargoes like grain, ore, and coal, and many, many others, containers, of course. There are also about 55,000 ocean-going ships, so there are many objects which can form the subject of disputes, and frequently do. In this field, arbitration cases have contributed very significantly to the development of English contract law, and you only need to look through the list of parties in the law reports to see what a very large number of them are shipping companies or transportation companies of one sort or another, going back in many cases well over a century. And this continues to be the case. There is a significant crossover with land-based construction and civil engineering contracts, and that is perhaps most noticeable in the field of ship construction, or the construction of oil rigs or floating production platforms. And in those cases, different forms of contract may be used depending on the predilections of the parties and whether they see it as being a maritime contract or a land-based civil engineering type contract. And most of these cases are international. They provide classic examples of problems which have to be resolved according to the conflict of laws. Most of the contracts we're concerned with are actually expressly governed by English law and subject to English jurisdiction, whether it's court jurisdiction or arbitration. But nevertheless, we have to take into account the laws of many other countries and sometimes parallel proceedings in other countries, which may try to stop the arbitration proceedings in London, and which frequently give rise to the interim form of relief known as an anti-suit injunction. I mentioned before ad hoc arbitration. LMAA arbitration is a prime example of ad hoc arbitration. And in the maritime field, it is the by far and away the most used form of arbitration. Most maritime arbitration comes to London, as I'll show you in the next slides. But first of all, just to dwell a little on the distinction between ad hoc arbitration and institutional arbitration, with which many of you may be more familiar. Institutional arbitration is the type of arbitration conducted by bodies like the International Chamber of Commerce, based in Paris, or the London Court of Arbitration, based in London, or the Singapore International Arbitration Centre, or its counterpart in Hong Kong. The Stockholm Chamber of Commerce is another important institution. We are not an institution, and we conduct arbitrations, or rather the arbitrators, the LMAA arbitrators themselves conduct the arbitrations, which requires the parties to have a very high degree of confidence in the arbitrators to actually run the proceedings. It's not an institution which runs the proceedings. The LMAA doesn't run the proceedings. The arbitrators run the proceedings according to the mandate which is given to them in the Arbitration Act, Section 33, which requires them to devise procedures which will conduce to the arbitration being conducted expeditiously and cost effectively. Could I have the next slide, please? So how does London International Maritime Arbitration stack up? Well, compared with the London Court of International Arbitration, which had something like a record of 450 cases in 2020 and thought it had a lot to shout about, the LMAA has over 3,000 appointments of arbitrators a year, which we record. And according to a formula which we adopt, we believe that this amounts to 1,600 new arbitrations which are started. So it's 4 times as many as are started in the LCIA in a record year. And those result ultimately in about 500 awards. And this figure has been very consistent over the last 15 years or so. And those 500 awards are the result of about 100 hearings, that's oral hearings, where counsel are usually engaged to plead cases, and about 400 cases which are decided on documents only. The rest, the other 1,100 perhaps, being settled at some stage during the proceedings. And again, it compares within the shipping field, the LOF salvage forms of arbitration, which is a rather distinct sub-area of maritime arbitration, about 100 cases a year, and the numbers have been declining as there have been perhaps fewer, if more spectacular, accidents. And the International Chamber of Commerce, which outside the LMAA and other ad hoc bodies probably has more new arbitrations in a year than anybody else. Internationally, it records about 700 to 800 new cases, about 72 of which are or were in 2019 seated in London. This compares in court proceedings with the numbers recorded by the English Commercial Court of about 1,200 claim forms a year. That's 1,200 new cases started in the English Commercial Court. So you can see that the number of new LMAA cases far exceeds the number of new cases started in the Commercial Court of all types, maritime or otherwise, far exceeds the number started in the London Court of International Arbitration. And if we can compare this also with other international arbitration institutions, you will see that the position is similar. Can I have the next slide, please? So we have 1,600 new arbitrations, 500 awards, 100 hearings. New York, in the maritime field at least, has now, we estimate, and no one has disproved this or argued with it, less than 100 new cases a year. all their awards are published, and therefore one can tot up the number of awards and get a pretty good idea of how many cases there are. In Hong Kong, in both ad hoc arbitration and in the Hong Kong International Arbitration Centre, there are probably in excess of 100 cases a year. In Singapore, the Singapore Chamber of Maritime Arbitration recorded 46 new cases last year, and the Singapore International Arbitration Centre claims to have about 70 new arbitration cases a year. So that's very, very significantly less than 10% of the new caseload each year of the LMAA. And in Paris, the Chambre arbitrale, again, its numbers have diminished dramatically in recent years. I put the 2013 figure there, but the 2019 figure is no different. It is very significantly less than 50 and may indeed be even less than 20. So could I have the next slide, please? Well, where do all these arbitrations in London come from? Well, the principal countries involved are, perhaps not surprisingly, the countries which are most actively involved in ship owning or shipbuilding. Korea being the #1 shipbuilder in the world, China being the #2 shipbuilder in the world, India not being perhaps such a major shipbuilder, but nevertheless being significant in international maritime transportation, Greece being a very, very significant ship owner, at least in terms of controlled tonnage. Something like 30% of the world's bulk carrier tonnage is controlled from Greece or by Greek nationals, and something like 35% of the world's tanker tonnage is likewise controlled by Greek interests. Other European countries are also quite significant. Germany, France in the container industry, perhaps particularly, and Norway, although rather less than in earlier years. And by business sector, we deal with disputes involving ship owners, charterers of ships, shippers, the people who provide the cargo to put on the ships, consignees, the people to whom the cargoes are delivered, agents of various forms, whether ship brokers, port agents, shipping agents, and so on. Significant players are shipyards, particularly in Korea and China, to a lesser extent perhaps in Japan, and financiers who are involved in ship finance, whether in the form of leasing or in the form of more traditional ship mortgage finance. Can I have the next slide, please? And what types of contracts are we concerned with? Well, in particular, contracts for the sale and purchase of ships, second-hand ships, yachts, offshore units like floating production and storage units, and shipbuilding contracts for new ships. We're concerned with charter parties and contracts of affreightment, charter parties including both voyage charter parties, where a ship may be chartered for, say, a single voyage to carry one particular cargo, or time charter parties where the ship is chartered for a period of time, maybe a year, maybe even 5 years, for the charterer to carry a whole series of cargoes, probably under sub-voyage charter parties. And we deal with contracts for the carriage of goods by sea, which are normally under the terms of bills of lading issued by the master or ship's agents and delivered to the consignee. The bills of lading, those of you who are familiar with maritime law will know, are the documents which unlock the delivery of the cargo. They have to be, at least in theory, presented to the master of the ship for him to deliver the cargo, and they have to be delivered to the issuers of letters of credit to secure payment for the goods which are transported. And we deal a lot with commodity contracts for the sale of, for example, steel or iron ore or grain or coal and such commodities. Can I have the next slide, please? Well, why do so many of these cases come to London? I've said that something like 95%, certainly 90% of the world's international maritime arbitration cases come to London, and we can say that with a fair degree of confidence. We would say that it's partly down to the experience of the arbitrators. We have a larger number of experienced arbitrators in London than anywhere else in the world. We have a lot of experienced and available expert witnesses, whether charter brokers, marine engineers, surveyors, and and those who may need to be brought in to give evidence in these cases. We have a lot of experienced lawyers. There are probably at least 40 specialist maritime firms in London with very varying sizes. But again, as a cluster, it is far larger than anywhere else. And we have the experience and assistance of the commercial court in supervising and hearing appeals. The commercial court has developed a very cooperative stance in relation to particularly London-seated arbitrations, but to an extent in supporting arbitration internationally. So this is a very much a symbiotic relationship. And one of the reasons, for example, why we don't feel in maritime arbitration we have a need for emergency arbitrators, because people can go to the commercial court to get the emergency sort of relief which they might otherwise need to get from an emergency arbitrator. Arbitration is relatively speedy. We're sometimes criticized for being too slow, but we do take steps to try to deliver awards as quickly as we can. And we have a lot of experience, not only in arbitration in general, but in actually running ad hoc arbitrations with a minimum of bureaucracy. If you ask anyone in the maritime field, they will tell you that it is cheaper to have an ad hoc maritime arbitration under LMAA rules than it is an arbitration in the LCIA or in the ICC. There is far less bureaucracy involved, and as a result, it can, generally speaking, be faster. And the rules of the LMAA are tailored to practice. We revise them every 4 to 5 years, and indeed, this year we have just published a new version of them, which, amongst other things, take into account the protocols which need to be followed in holding virtual hearings, something which, of course, has burgeoned in the last year when we've had the problems arising from the pandemic. Now, the next slide. Well, we have a number of different terms and procedures, depending very largely on the amount involved in the case, which doesn't necessarily correspond to the complexity of the case. Our main terms are really designed for almost any amount, and the procedure is probably not 100 miles away from typical court proceedings, including very often a hearing. Most of the cases which go to hearing are indeed under the terms. We have an intermediate claim procedure, which is designed to deal with cases of between about $100,000 to $400,000. And a lot of maritime cases do fall within this band. A lot of cases involving claims for balance of hire, for off hire, for speed and consumption shortfalls, for off-spec bunker claims and so on, tend to fall within the spectrum. But in fact, the intermediate claim procedure is not used as much as we like. And in practice, a lot of these claims actually are dealt with under the 2021 terms, or under the small claim procedure, which is really only intended for claims of under $100,000, but which is very, very popular in the industry. Can I have the next slide, please? So the LMAA, what is it if it's not an institution? It's an association, an unincorporated association of practicing arbitrators. It was founded in 1960, really grew out of the Baltic Exchange and its informal procedures for the resolution of disputes. So it's now nearly 61 years old. It has currently 40 full members who come from a variety of backgrounds. A lot of them are lawyers, about half of them are perhaps lawyers, but the other 50% are from the maritime trades, from shipbroking, insurance broking, naval architecture, or maritime surveyors or engineers. In addition, we have, now this is rather out of date, we have some 800 supporting members who have an interest, very often stakeholders, in some way in the process of maritime arbitration. And we have also some 30 so-called aspiring full members who might regard as candidate members, people who have many of the attributes we look for in full members, but probably don't yet have the experience we would require of full members. But anybody can be appointed as an arbitrator. You don't have to normally appoint a full member of the LMAA unless the arbitration agreement says you must. Not many of them do. And so you can appoint anybody on on the street if you want. In practice, the defence clubs who fund much of this litigation are quite conservative, and they tend to go for full members of the LMAA, perhaps more than anyone else. But otherwise, members of the bar very often sit as arbitrators in maritime cases too. So we're not an administering body, nor are we an arbitral institution. We have very limited administrative functions. In small claims procedure cases, the president can make default appointments if the parties, as often the case, can't agree on the identity of a sole arbitrator. But that's about it. We make rules, we update our terms, and we have a code of ethics governing the way in which arbitrators behave. Can I have the next slide, please? Well, we're not free to do anything we like. Unusually, in London, we have an appeal process where there is a right of appeal on points of law. And this is almost unique internationally, because all other jurisdictions which follow more or less word for word the model law on arbitration promulgated by UNCITRAL, the right of appeal on points of law is excluded. In London, it's included. And it's included because when the model law was considered by the Departmental Advisory Committee in the early 1990s, it was decided to retain the right of appeal on points of law, partly in order to make sure that the English commercial law, as published and as reported in law reports, would be kept up to date. And indeed, that has proved to be the case. There are those who say that there are not enough appeals, but the majority view appears to be that the gateway and the threshold, the hurdles for appealing on points of law is about right. You could also appeal on grounds of jurisdiction under Section 67, or because the tribunal has committed a serious procedural error under Section 68. So we are subject to the supervisory jurisdiction of the English Commercial Court. And one of the advantages of that, you may say, and I think parties in the maritime field in particular think, is that English Commercial Court judges in many cases have maritime experience. They are people who practiced before becoming judges as maritime counsel. And so they are very experienced in these types of cases. If you go to the intermediate claims procedure, there are very limited rights of appeal from the ICP, and this is deliberately provided to restrict rights of appeal. So if you opt for the ICP, you know that that is the case. There are no appeals from small claims procedure awards. So you recognize that the arbitrator's decision is final, also on the law. Awards can be reported with the party's consent. Very often we find that the losing party does not consent, which unfortunately limits the number of arbitration cases which are reported. Awards are not binding, but they can be informative in terms of the understanding of the way in which arbitration tribunals work. For example, in relation to speed and consumption claims, how they will charge party clauses will be interpreted in future. But appeals where they do go forward are always reported in the law reports and do contribute to the development of the English commercial law. Can I have the next slide, please? So LMAA arbitrations are ad hoc. I've explained what that means. They are generally subject to the LMAA terms and procedures. Even if this is not stipulated in the arbitration agreement, the arbitrators, in formulating the procedure, as they're entitled to do under the Arbitration Act, may very well adopt the LMAA terms because they are very practical and very flexible. And the arbitrations are subject to the mandatory provisions of the Arbitration Act 1996. Those who've studied the Arbitration Act will know that it contains both mandatory and non-mandatory provisions. The non-mandatory provisions are in many cases superseded by the LMAA terms and procedures. Quite commonly in our process, and this is a surprise to some from outside the maritime world, only two arbitrators will act. That is the party appointed arbitrators, even if the arbitration agreement makes provision for three arbitrators to be appointed. This is because the LMAA terms make provision for the two arbitrators to proceed. This is much more cost effective without appointing a third arbitrator, unless and until they disagree or until a hearing is imminent, at which point they will need to appoint a third arbitrator. So very many of the awards, I think I suggested 400 a year, will be decided by 2 arbitrators or possibly by a sole arbitrator without the appointment of a third. And we would say very cost effectively, 80% of maritime arbitration references are decided on documents only. That is, they don't have an oral hearing. Oral hearings are generally very expensive, and parties where they don't need to cross-examine witnesses will be able to get a decision on documents only. And this is very popular, but relatively unusual otherwise in international arbitration. And you may find that it's also quite interesting that I found that many of the commentaries on the process of virtual hearings during the lockdown, as well as recent reports by the ICC and the Commercial Court Users Committee and changes to the CPR, have rather tended to suggest that witness evidence is less reliable than has perhaps traditionally tended to be considered in the past. In particular, new rules have suggested that witnesses it should be very clear that witnesses only put in their statements matters which they are within their personal knowledge, and that they do not try to be advocates in their case. And this may have some impact on the use of witness evidence in future. Can I have the next slide, please? So under the Arbitration Act, we as maritime arbitrators have very wide powers. We have nearly all the powers that the commercial court has. We have power to order security for costs, and this is indeed quite commonly done in maritime arbitrations. The claimants are very often, say, one-ship companies. Very often the ship which is the subject of the dispute has been sold, so that the claimant has limited resources, and the respondent might quite justifiably apply for the arbitrators to require the claimant to provide security for costs if the claimant is unsuccessful in its claim. We have power to give directions in relation to property involved in the proceedings, to order the inspection of property, preservation of property, custody of property, detention of property, and sampling and experiment, all of which may be important in relation to the provision of evidence in the case. Can I have the next slide, please? We have wide powers to make declarations, so it's not every award which will actually order payment of a sum of money. It may be that we make a declaration that someone is entitled to an indemnity, for example, or a declaration as to the proper construction of a contractual provision. But above all, we have power to order the payment of a sum of money, as we frequently do. And we also have power to make partial and provisional awards. I mentioned the case of the Costas Mellis. This is very often used in maritime cases where there is a claim for hire by a ship owner, and the charterer says, yes, but I'm entitled to deduct off hire because the ship wasn't available to me for the whole of the charter period. Now, it may be that despite that off hire claim, the arbitration tribunal is persuaded to make a partial award. That means for part of the case or part of the claim, so that it awards a sum of money to the ship owner, and it leaves to a future determination the counterclaim by the charterer for off hire. In those circumstances, it would be possible to require the claimant, having received the award for a sum of money, to give security, so that if the charterer is ultimately successful on its cross claim, that there will be some money available to meet its award. The arbitrators have the same powers as the court to issue injunctions. Perhaps they're asked to issue injunctions rather less often than the court is, because of the powers of the court in relation to contempt, so that where parties fail to comply with an injunction issued by a court, the offending party, directors of the company, for example, could be sent to prison for contempt. So although most of these cases are international, if you find, for example, a Taiwanese director of a ship-owning company happens to be transiting through Heathrow, and a sharp claimant has spotted that he is transiting and is within the UK jurisdiction, as has happened, he could be served with process in London and could be detained, which is probably will not make his day. So the court has certain powers in relation to injunctions which arbitration tribunals don't do, but nevertheless arbitration tribunals do have powers to issue injunctions. We have orders, the right to order specific performance, but we're probably as reluctant to order specific performance as indeed the courts generally are, unless the circumstances are very clear. We have powers to order rectification of documents where it's proved that a contract doesn't correctly evidence the bargain which the parties came to. We could set aside or cancel deeds or other documents, but the evidence has to be very clear before we would use those sort of powers. Could I have the next slide, please? Well, as you can see, we're at the end of my presentation, and I hope that's given you something of the flavour of London maritime arbitration, and in particular, given those of you who are not familiar with the sector, an idea of the huge scale of this industry and of maritime arbitration in London. Maritime arbitration in London is quite dominant in this field. It's very rare to find an industry or business which has a 95% market share, but that's where we are at the moment, and that's where we're determined to remain by providing an efficient and competent service. So I'll hand over to what I'm sure will be a much more interesting and topical presentation by Clive. All of you will have heard of the Ever Given, even if you've never heard of the LMAA, being the ship that got stuck in the Suez Canal, and which continues to provide us with much interest, as well as provide lawyers with a great deal of lucrative business. So thank you very much indeed for listening. We're very happy to take any questions you may have at the end. Thank you. So Clive, I'll hand over to you.
Thank you, Ian. As Ian said, the case of the Ever Given was one of the rare occasions when the person in the high street became aware of shipping and something of what the shipping industry does. And for a while, it was a case that seemed to be on everyone's lips discussing it because it captured the imagination. Next slide, please. I've been asked to do a case study on the Ever Given. It's a little bit premature, really, to do a case study because these events happened very recently, and neither the ship nor the cargo on it have actually, as we'll see in a minute, gone very far since then. But this is a picture of the Ever Given. As you can see, it slid its way across the Suez Canal, blocking traffic in all directions. And this picture gives a sort of a visual idea of the size of the ship and the nature of the problem. Next slide, please. What I'm going to try and do this afternoon, as I say, this can't be a proven case study, but I can go through the way in which it's likely to pan out and the way in which arbitration may have a role to play in some of the disputes that arise out of the Ever Given case. Now, unusually, I say unusually because very often people think of shipping when they've seen cases of vessels catching fire and polluting beaches. This isn't the story of a rust bucket with a suspect background causing trouble. The Ever Given was a very modern container ship. It was built in 2018, and it was capable of carrying the mind-boggling quantity of 20,000 odd containers with an approximate weight of 200,000 metric tons. Well, to give that some context, think of the lorries you see driving on the road, usually carrying just one container. And imagine that multiplied by 20,000, and you get some sense of the size of the ship and then the nature of the problem when that ship goes out of control. It was about 400 meters long, and its value was about 100 million US dollars. So it was a very expensive, sophisticated, and modern piece of equipment. and it was said to have lost its steering because of strong winds and a sandstorm whilst transiting the Suez Canal en route from Rotterdam to Felixstowe. Next slide, please. It was aground for just 6 days before being towed off the bank, and it was taken to a safe place just at the end of the canal, where it remains until today under arrest. Next slide, please. So why did this all matter, and why did people get so excited about it? Well, let's go back one slide, if we may. It mattered, perhaps another slide back, it mattered because 12% of the world's trade passes through the canal each year. And if you put that into figures, it means that about 50 to 100 ships pass through the canal each day, carrying cargo worth anything between $3 and $9 billion. And when the canal was blocked, you were looking at ships there that were blocked, that were carrying anything from toys to foodstuffs. So it was vital for everybody that the canal be unblocked. But it's also apparent that a short delay, just 6 days that we're talking about, it may not seem very long, but 6 days was always going to have a huge impact and involve very large sums of money. And that's one of the reasons why, obviously, it's going to be such a major case for years to come. Next slide, please. So if we start by looking at the parties and the types of contract that will be involved in the Evergreen. The owners of the ship were a very respectable Japanese ship owning company, and they had time chartered the vessel out to another equally well-known and reputable shipping company from Taiwan called Evergreen. Now, the nature of a time charter is basically that the vessel is hired out to Evergreen for their commercial operation. They arrange for the port calls, the bunkering. They effectively have full use of the vessel, although the crew on board remain the employees of the ship owner. Now, Evergreen would have no doubt chartered out some of the container slots on board the ship to other container line operators. And there's a great deal of cooperation between the major players in the container trade, that they may not be able to fill all of the container spots on their ship themselves, or they may urgently need to ship their own containers when they don't have a ship available. So they have these arrangements whereby they charter out slots to other companies. There are also some slots that are chartered out directly by Evergreen or by these slot charterers to other smaller freight forwarders who are described here as NVOC, non-vessel owning companies. Now, the contracts of carriage for the cargoes on board carried in the containers might have been issued by any of these parties. Some will have been issued by Evergreen, some by the slot charterers, and some by the NVOCs. So the contracts of carriage are not by any means going to all be the same. There will be quite a range and variety of contracts. So the other parties involved, the Suez Canal Authority, the salvors, and the owners of ships that were blocked, and the owners of cargo on board those ships that were blocked by the obstruction of the Suez Canal. And for all of these interests, there are going to be insurers. So there will be hull and machinery insurers for the ship. There will be insurers for all of the cargo on board, many different insurers with 20,000 containers. And there will be third-party liability insurers, known as P&I insurers, for both the owners and the various charterers and operators who had an interest in any part of the performance of the voyage. Next slide, please. Well, the headline grabbing claim, and if we can do one more click. The headlining claim that people have heard of comes from the Suez Canal Authority. Now, that's not going to be a contractual claim, I don't think. It's largely going to be tortious. And it's a claim that was originally advanced for $916 million against the owners of the ship. And it's a claim that from the owner's point of view will be handled by their P&I insurers predominantly. Now, I said earlier that the ship and the cargo haven't gone very far, and that's because the Suez Canal Authority won't let the ship go until they have either a payment or a mixture of payment and security for their claims. And the last I heard, if we can do one more click, is that they were still negotiating, and one more click. And the figures I had heard is that the Suez Canal Authority were looking for a deposit of $200 million and an insurer's guarantee for about $350 million. And the types of claim that they're looking at, well, you can see on the right-hand side, number one, possibly loss of business. Number two, anti-pollution. Number three, sadly, a member of, I think one of the tugboats assisting was killed. And also, I think, a marine unit that was assisting sank. So it's a variety of claims. So far as concerns arbitration, we won't get involved directly in those claims pursued by the SCA. Next page, please. And if we can do probably, perfect. And one more. So I'll start with the claims in tort. We've already seen the Suez Canal Authority claims, claims by the owners of delayed ships, claims by the owners of cargo on board those ships. Those are largely going to be tortious claims because there's no contractual relationship between the owners of the Evergreen and those parties. Those claims are unlikely to come to arbitration unless by agreement. And I added that caveat because even in cases of tortious claims, it is sometimes agreed that the dispute will be referred to London arbitration as a neutral venue. And a very good example of that is where there may be some agreement as to the liability of a party, but some dispute as to the quantum of their claim. And arbitration is often agreed by the parties as the best way of resolving that. So we might see some of these claims come to London, but a lot of them, I suspect, will not come to London arbitration. Next slide, please. So what I'm going to try and do here is go through the claims in the order in which they're likely to arise. And the first type of claim that is going to arise is for salvage. Now, salvage is the reward paid to the salving party, the owner of tugs, cranes, etc., that are used to bring the ship, the cargo and the bunkers to a place of safety. Usually, these parties are rewarded under what's called Lloyd's open form. And this may be known to many of you. Lloyd's open form, which is beginning to decline, but traditionally was the no cure, no pay contract by which if a ship was in peril, the master would send out his SOS and the salvage companies would all race out with their tugs, and the first one there will get the master to agree Lloyd's open form on behalf of the ship, the cargo, and other interests. And the dispute would then be referred to the Lloyd's salvage branch in London, and an arbitrator would be appointed, and now there are 3 senior barristers here who deal with this. And the arbitrator decides the value of the services that were rendered by the party. Now that will depend on the complexity of the dispute. It will depend on the expenses incurred. So some salvage operations now are very, very complex, and so the sums involved are huge. If the agreement isn't on Lloyd's open form, it may be a negotiated contract with salvors. And this will be a tailor-made contract that the parties agree. Many years ago, I was involved in the removal of a ship that grounded in Mogadishu, and we had a daily rate contract with the salvors, which meant basically that each day we had to have reports and be satisfied that as much as possible was being done as quickly as possible. In both of these cases, though, the likelihood is that the matter will come to arbitration in London. It may not come to the LMAA, it may go to the Lloyd's salvage branch, but again, even in this type of case, it's not unusual to see the quantum, the issues of commercial loss, etc., hived off for LMAA arbitrators to deal with. Next slide, please. The next type of claim that's likely to arise after salvage is general average. Now, this is where the parties to a maritime adventure, as we rather strangely call it, the parties on a voyage who benefit from the payments or sacrifices made when the voyage is in peril, they all contribute to the expense or the sacrifice according to the value of their interest. Let me put that in a simple way. Obviously, there are going to be a lot of expenses when a ship is in trouble. The cargo may have to be towed off a bank, as with the Ever Given. It may be that some cargo has to be taken off, carried somewhere where it can be reloaded later on board the vessel. It may be that some cargo has to be thrown overboard and destroyed. But there are expenses involved, and the concept of general average is that everybody shares in that expense according to the value of the property that they have an interest in. So those who may be involved in claims for general average will be the owners of the ship, the cargo, and possibly the fuel if it's separately owned. So usually what happens is the owner declares general average, appoints what's called a general average adjuster. He or she will collect from all of the interest concerned security to cover their eventual contributions in general average. Now, whether this will come to arbitration or go to court may depend on the identity or the place of the guarantor. A large number of these claims do, however, come to London arbitration. They're perhaps not often very controversial. Normally, a lot of trust is put in the average adjuster, and it's relatively unusual to see the average adjuster's calculations challenged. The real litigation comes a little later in the next step, which is covered on the next slide, please. And this is really where you're going to see the large number of claims come through eventually, and that's claims by the cargo owners. And by that, I'm talking really about the owners of cargo on board the Ever Given. Now, the cargo is not damaged by the grounding, but it's been delayed in reaching its destination. Indeed, it's still not there. So this may cause deterioration of the cargo or loss of market claims with or without physical damage. Imagine if this had been several months later, we might have been looking at a container ship full of toys made in China for the Christmas market. And of course, there would be huge loss of market claims if the Christmas market was missed. So there may be that type of claim. But also the cargo owners may sue for what they've had to pay to the salvors or in general average. That's money that's come out of their or their underwriter's pocket that they were looking to recover from somebody. Next slide, please. So these claims will mostly be brought by the owner of the cargo or their underwriters under contracts of carriage that are usually contained in bills of lading. Now, as I mentioned earlier, the bills of lading may be issued by any number of people. It could be the Evergreen or one of the operators using slots on board that ship. So uniformity is not guaranteed. So who do the cargo owners sue? Well, that depends on the identity of the carrier under the bill of lading. It could be the owners in some cases. It could be Evergreen. It could be the slot charterers or NVOC. So in each of these cases, one's going to have to look very closely at the contract to see who is the contractual partner for the holder of the bill of lading. And each form of bill of lading will have its own dispute resolution provisions, but it's fair to say that these will usually provide in some way for arbitration. And indeed, the evergreen contracts provide for resolution in London. Next slide, please. Now, each bill of lading is a separate contract of carriage. And so theoretically, there could be a separate arbitration for each bill of lading. Now, with 20,000 containers, often containing more than one consignment of cargo, potentially one would be looking at a huge number of arbitrations. In reality, though, that tends not to be the case, because although the Arbitration Act doesn't provide for consolidation of actions, in practice, actions tend to be consolidated by underwriter, port of call perhaps, law firm involved, or recovery agents involved. And that's when we get appointments for cargo claims, there tend to be a large number of bills of lading covered in one reference. And although there isn't a formal consolidation, there is a de facto consolidation. So we're not going to see 20,000 arbitrations here. We're going to see a far smaller number, but nevertheless, still quite a significant number. Next slide, please. Just one point, I mean, we'll keep on this slide, but I mentioned there test cases. Occasionally one sees a test case in shipping, but it's fairly rare to see a test case in my experience in cargo claims. So what type of issues are going to arise in these arbitrations that may come to us probably in a couple of years' time? Well, the first issue is going to be that of causation. Unseaworthiness, which involves if the ship was unseaworthy, there may be liability on the part of the owner. If there's crew negligence, latent defects, or perils of the sea, then there may well be an exception to liability under the Hague or Hague-Visby rules that would apply to the contract of carriage. But simply bringing a claim under the bill of lading may not be the end of the matter, because what if liability is established against, let's say, Evergreen, what can they do to pass it on? Well, they may seek to pass on the claim by way of an indemnity claim against the owners of the ship. So we may find that, and often do find, that these claims are pursued in stages. Cargo owner against carrier against owner of the ship itself. And each of these would have its own arbitration provision, particularly under the time charter between Evergreen and the owner. Next slide, please. So if I'm the owner of the Evergreen, what type of claim am I going to anticipate being pursued against me? Well, I'm going to see cargo and other claims, perhaps for salvage or general average indemnity, passed on to me by the charterers. I may also see, I probably will see, claims from Evergreen for time lost, because Evergreen are paying hire on a daily basis to the owner. And so for time lost, they're going to want to stop paying hire, at least until the vessel is back in service. And there may be other consequential commercial losses they would want to recover. So there may be, these claims may be passed on to the owner by Evergreen under the charter party, which will have a London arbitration provision. So what defences might be available to me? Well, on an overall basis, there is the Convention on Limitation of Liability for Maritime Claims, whereby an owner can set up a fund if there are huge claims, set up a calculated fund based on a number of factors that will cover all of the claims, but go no further than that. This normally happens in the major disaster claims. On a smaller basis, you may have claims for package limitation for high value packets of cargo, where the Hague rules may provide, or Hague-Visby may provide, for some form of limitation. I've already mentioned that they may have defences about negligent navigation, latent defects, perils of the sea. And they may also take advantage of what's called the P&I Interclub Agreement, which is an arrangement that the insurers have between themselves to try and, on a sort of cheap and cheerful basis, apportion claims where the liability is in issue. So rather than argue who's liable of the two parties, they agree to some 50-50 or other apportionment between underwriters. If these come to arbitration, there will obviously be issues of technical nature in relation to any mechanical failings. There may be evidence as to navigational errors requiring former seagoing captains to give evidence, and there may be questions as to the quantum of the loss. Next slide, please. I've just added this because the container ship is a very unique type of ship. And I've just put here, what would have happened if this had been a bulk carrier? And by that, I mean a ship that instead of having 20,000 different containers, just had its holds filled with grain or coal, etc. Well, there would have been fewer claims because the cargo would probably have been owned by one or certainly a smaller number of parties. And there may have only been one contract of carriage and bill of lading. The contract of carriage may have incorporated charter party terms, but legally there may be disputes for the arbitrators to decide as to which charter party is incorporated into the bill of lading. What if the ship had been heading in the opposite direction? As it happens, the vessel was heading to Europe, where the jurisdiction provisions of the contracts of carriage would likely be respected. If, however, the vessel was heading perhaps, let's say, to China, the Chinese courts would have been far less inclined to accept the jurisdiction contained in a bill of lading that the receiver may not have seen or agreed to before it was negotiated to him under the sale contract. In that situation, you may have found that would have been anti-suit injunctions brought in the English court to prevent the Chinese court or Indian court, wherever it may have been, from taking jurisdiction over the cargo claims. And nowadays also one then sees anti-suit injunctions in China to try and outlaw the anti-suit injunctions brought by the English courts. So it may well have been that in a different situation, there would have been multi-jurisdictional conflicts to determine where the claims should be decided. And if instead of transiting the Suez Canal, the vessel had been going into port, well, then the owners might have claimed against Evergreen by saying that the port itself was unsafe and that all of the damage and loss that they suffered should be covered by Evergreen, who would have promised to send the vessel only to safe places under the contract. So as you'll see, it's too early to say exactly what's going to happen in this, but I hope that at least gives you some idea as to the way in which this may pan out in the future. And as one can see, the initial involvement of arbitration may be limited, but as we get further into the claim, then there is far greater scope and the likelihood of arbitrations taking place. Next slide, please. So shipping law may be complicated, but it's very rarely dull. Thank you very much.
Thank you, Ian and Clive, very much for those fascinating talks covering a very broad range of topics. In terms of questions, while Clive was talking, Ian was actually answering a question in the chat regarding requirements for membership of the LMAA. So if anyone is interested in that information, there's a link and some info that Ian provided in the chat there. Few questions that we've got. The first one from Andrew, I assume will go to, is aimed for both of you. Could you comment on the impact of Brexit, if any, on the popularity of London as the #1 seat for arbitration? I suppose maybe to Ian first, because he spoke about the LMAA in general.
Yes. The impact is certainly not negative, and it may be slightly positive. The first point to note is that the enforcement of London Arbitration Awards is governed by the New York Convention, which has nothing to do with Brexit or the EU at all. There are 160 or so countries which are signatories to the New York Convention, and in principle, an arbitration award which is obtained legitimately, unless there's some procedural error in one of those countries, will be enforced as a court judgment in all the other 160 countries, which makes arbitration especially powerful. And it's indeed one of the reasons why people frequently prefer maritime arbitration to resolving maritime disputes in the English courts, because court judgments, of course, are only enforceable in other countries as a result of either multilateral treaties, bilateral treaties, or in some cases on the basis of reciprocity. So the New York Convention will continue to make sure that English arbitration decisions are enforceable worldwide. In relation to those cases which are subject to court jurisdiction, there may be some questions about the enforceability of English court judgments under the Lugano Convention, to which the UK, I think I'm correct in saying, is no longer a party as a result of Brexit. There are ongoing discussions at the moment with a view to trying to enable the UK to accede to the Lugano Convention, but the vast majority of these cases are in arbitration. They will continue to come to London, we expect, because the London Arbitration Awards will continue to be honoured without any problem. And there may be some slight potential upside in that some of you will be aware that as a result of a rather celebrated decision some years back, the English courts effectively withheld their jurisdiction to issue anti-suit injunctions restraining the bringing of proceedings or continuation of proceedings in EU countries where the EU court in the relevant country or an arbitration had accepted jurisdiction under the principle of first seized. This was involving where proceedings involved parties which were situated in Europe, did have some disadvantages perhaps for parties arbitrating in London, where it meant that at least one of the usual weapons which is available to stop parallel proceedings was not available in cases involving European parties. As Britain is no longer a party to the relevant convention, to the Brussels regulation which governs this, or to the jurisdiction of the Court of Justice of the European Union, the English courts are in principle able to issue anti-suit injunctions, also involving proceedings in other EU countries. So that is the answer. I mean, there are a body of people outside the UK who have tried to suggest that Brexit will have some impact on a negative impact on the number of parties who want to arbitrate or litigate in London. I think that's simply not going to be the case.
Great. Clive, did you want to add anything to that?
I think Ian's covered the point.
Great. Okay, next question we have. Mr. Aston referred to consolidation of multiple arbitrations. Can either speaker comment on the differences between LMAA terms and, for example, ICC or LCIA rules in relation to, for example, concurrency of arbitrations and sharing documents and evidence across separate arbitrations, either with or without consent of the parties? And how does the approach of LMAA arbitrators generally compare to that of institutions regarding situations involving a multiplicity of related disputes? I don't know which of you might like to take a stab at that one.
I don't mind kicking it off, but I probably need a little bit of input from Ian as well. The position under the Arbitration Act generally is that consolidation is not permitted for separate arbitrations. The LMAA is, I think, rather unique in that it makes provision for not consolidation, but concurrency of arbitration. And by that is meant that where separate arbitrations raise overlapping or very similar questions of fact or legal issue, the arbitrators have the power to order that the references be dealt with concurrently, and that the disclosure that's given in each reference is made common to all. Now, this very often happens where you have a chain of contracts. You may have an owner, a charterer, and a subcharterer. And quite often a dispute that arises involving those three parties will involve the same issues, but strictly speaking, there should be separate arbitration references. What the LMAA terms provide is that we can say to those parties, well, we're going to deal with these matters concurrently, which means that you will copy each other in to messages exchanged in the reference, and whatever is disclosed in the arbitration between the owner and the time charterer will also be disclosed in the reference between the time charterer and the voyage charterer. Now, parties are familiar with this, and so what they've tended to do is do as much as they can to ensure that the tribunals in those separate arbitration references are common, or that at least there are one or two arbitrators who are common. And the great benefit of this is that it streamlines, rather than having to have one arbitration, get a result, follow it up with a claim for an indemnity in the second arbitration. It can all be dealt with in a far more direct and cost-effective way. So in that sense, I think that the LMAA's system is fairly unique, because so far, at least as I'm aware with ICC, consolidation, if it is available in very limited circumstances. I think that the parties have to have agreed to consolidation. And in the same way, I should add that in LMAA arbitration, if the parties agree consolidation, then we will proceed. But ICC require that there has been an agreement to consolidate. I think also that the claims are made under the same arbitration agreement, or they're made arising under the same legal relationship. But it's a fairly restricted availability, and I don't think that the ICC have the same provision for concurrency that we do. LCIA, I think, have changed their terms in 2021. And I must admit that I'm not fully familiar with the changes they've made, but I think that they have made some moves towards involuntary consolidation, which have been regarded as a little bit controversial. And I'm not sure whether Ian is familiar with those changes.
Well, the answer is not. I'm just looking at the LCA terms, the previous ones of 2014, which provide for consolidation in only very limited circumstances, which, as Clive said, where the parties actually agree to the consolidation, or in some circumstances, consolidation of disputes under the same arbitration agreement or related arbitration agreements before the tribunal has been formed. I think that there are now slightly wider provisions for consolidation, but they are comparatively rarely used, or not been very much tested, I think, and are, as Clive says, controversial, because they, if you treat party autonomy as being the absolutely cardinal principle behind arbitration, then they do tend to conflict with the idea of what the parties have agreed. The same applies also to bringing in third parties on a compulsory basis, unless the third party, where the third party agrees, there may be procedures available under the LCIA rules or under the ICC rules to bring in third parties, even against their will sometimes, but in the majority of cases it's only with the agreement of those parties or on their initiative. But the same result tends to be achieved by the LMAA terms by the powers to order concurrent hearings and the sharing of documents and evidence, and the possibility of making an order that evidence in one arbitration should also stand as evidence in another arbitration. This very frequently occurs in the context of chain arbitrations, that is, cases where a ship has been chartered to party A and party A has chartered it to party B, maybe on back-to-back terms, maybe not quite. C, D, E, sometimes we can get chains of perhaps 5 charter parties in this form. And the same applies also in sales of commodities under GAFTA terms, the Grain and Animal Feedstuffs Trade Association terms, where again you often get a whole cascade of a series of contracts of sale of the same commodity, and where it's often convenient to pretend really that the end parties in both cases, the ultimate seller and the ultimate buyer, are in effect in a dispute together. But that works well, we find in practice, and there are a few cases where we really feel that the parties are disadvantaged by by the tribunal not having powers of consolidation as such.
Great, thank you. I think we probably have time for one more, what is hopefully a quick question. This is, would a tribunal seated in London apply overriding mandatory provisions, including Hague-Visby rules, irrespective of the parties' intentions? Open that up to either of you, depending on.
I think in a limited way that certain responsibilities can be contracted out of, but basically the rules are mandatory, and so it would not be possible for the parties to contract wholly out of them.
Indeed, it actually operates in many cases the other way around, and the charter party will actually expressly incorporate the Hague or Hague-Visby rules. So in effect, the parties have said, yes, we agree to that.
I mean, I suppose looking at that, one is also looking at the type of contract. There will be a difference between bills of lading and claims brought under charter party. One isn't going to be able to contract out for bills of lading, but charter party, various obligations may be divided there, particularly if it's a time charter party.
So just very briefly, I might mention in relation to bills of lading, and Clive referred to this, there are a very large number of cases where there is a conflict of jurisdiction between the jurisdiction of the courts in the receiver country and the arbitration provisions which one party, usually the owner, will claim are incorporated into the bill of lading. And this depends on really conflict of law principles as to which rules do you apply as to the incorporation in bills of lading of charter party terms, and in particular the arbitration clause derived from the charter party. And the rules which were adopted in England, for example, are different from those in China, and consequently the Chinese maritime courts may very well claim to take jurisdiction in circumstances where, according to English law, the arbitration tribunal appointed under the arbitration agreement, which under English law is incorporated into the bill of lading, would take precedence. So this is a frequent field for controversy.
Great, thank you. So I think we probably need to round things off now. I just say thank you so much to Ian and to Clive for such an interesting presentation and discussion. It's been great to hear from speakers who've got such broad experience. In Ian's case, as a barrister, members of panels of foreign arbitration commissions, and in Clive's case through P&I and his consultancy, and in both cases as very experienced arbitrators and ex-presidents of the LMAA. I think it's given us all some real insights into maritime arbitration generally and the potentially complex nature and ramifications of shipping disputes that perhaps aren't out there in the sort of public domain necessarily. And as this is our last lecture of the year, so I'd just like to very quickly say a few brief words of thanks to some others. First to the Lauterpacht Centre for their support, and especially to Vanessa Bistri for all of her work over the last 2 terms in organising these lectures, to our president, Ibrahim, and to the Lectures and Seminars Committee, which was chaired by Mikhail, who've done an amazing job of organising the series in what continue to be quite challenging times. And we very much hope that everyone will join us when the series resumes next academic year, and also for the Cambridge Arbitration Day conference, which will also take place at the start of the next academic year. And as attendees to this lecture, everyone will be on the mailing list, so you'll be notified when our events start up again. So I think all that remains for me to say is thank you once again to Ian and Clive for taking time out from the sunshine to talk to us today, and to everyone for attending, and I hope that everyone enjoys the rest of their evening. Thank you.
And can we also thank you, the organisers, in particular you, Alex, and Mikhail and Ibrahim, for inviting us and for providing the support for the lecture today. We very much enjoyed the opportunity.
No problem. Great. Great, thank you.
Thank you.
Bye-bye.
Bye-bye.